Thank you, Steve.
Andrew, stop sucking up.
Why not? It's fun.
Yeah, that's true. So, board certified.
Board certified. That's right. So yeah. So the Florida Bar has created a board certification program. They don't like when attorneys claim that they're specialists or experts in something. So they created a whole board certification. We have 9 attorneys that are board certified in condominium law. There is less than 200 board certified attorneys in the state of Florida in condominium law. So I'm certainly proud to be one of those. We also have a board certified construction attorney as well. And so we're definitely well suited to address any of those legal questions.
You know what this means, though? I can call you an expert and do it legally.
Absolutely. And I love it. We worked hard for it. We had to go to
No, yeah, I
Tampa,
know you do.
take a test. I mean, it was like, and it was funny seeing attorneys that have practiced for years. I don't care how old you are, there's a little bit of that test anxiety out there. So it certainly was a huge relief to have that done. And I'm certainly proud of that.
So, because Andrew, he's this good-looking attorney guy, our boards are filled with phone calls already. That's
Oh,
early
wow.
in the show. I know. All
That's
lines
great.
are booked, and they're from everywhere. They're from Miami. They're from Sarasota. They're from Vero Beach. From all over. This is the hottest show in South Florida. And I'm so glad that you could be with us tonight. And we're going to not only answer people's questions on the phone, but we've got. Did you notice all the emails that we got? That's
Wow.
just in 2 weeks.
Wow.
Emails that people have sent their question ins. So, hey, let's get ready. We're going to have a great show tonight. Again, if you'd
Let's
like to
go.
call us, 888-565-1470. Let's go to our first call. Let's go to Douglas in Vero Beach. Hey, Douglas.
Hey, Steve, thank you so much. And I can tell you, Andrew is a terrific presenter. I've listened to some of his webinars. Thanks for having him on.
Are you his cousin?
Andrew,
I know.
Yeah,
Douglas,
this-
are you a family member that I'm not aware of? That was awfully nice of you. And
Hey.
Thank you, Douglas.
I appreciate that.
just a fan. And Andrew, I've written my question out to make it concise so you can answer it. Our condo association document committee recently met in a posted meeting, discussed making changes to our declaration with 12 proposed amendments to recommend to the board of directors. And they just discussed them in concept form. The board of directors, upon receiving this list of concepts, voted by email without holding a posted meeting and approved via email 11 of the proposals, rejecting 1. Then the board, a few days later, posted a meeting notice with 48 hours notice with a rather vague 3-word agenda item which said ratification votes - amendments. No written documents were distributed with the agenda or at the meeting. And wrapping up here, the document committee chairman simply read out one at a time a brief that is 4 or 5 word description of each concept, knowing the board knew what he was talking about. And the board voted through each of those one at a time to send them to the attorney to put them in legalese form for them to be placed out in a vote of all the unit owners. I thought initially 14-day notice would be required since each of them impact unit owner use. I could be wrong on that. There's nothing in the bylaws that speaks to that.
Okay.
But I certainly believe statute is quite clear, says it's illegal to vote by email. And I'm uncertain as to the viability of these amendments if they get put out before the voters because of the flawed process that was followed. I may support them all, but I want them to be passed through a valid legal process so they aren't subject to being overturned. Could you please comment on this situation? I believe it was done wrong.
Sure.
And I'm wondering what to do about it.
Okay. Well, you certainly asked a multi-layered question, so let me try to address, I think, the three main points that you brought up. Regarding the notice of the board meeting for the board to approve which amendments they want to present to the homeowners, and this is for both condos, co-ops, and HOAs, that notice is just a 48-hour notice. The 14-day notice you refer to is when the board will be adopting rules and regulations regarding the use of the homes. Here it sounds like they were just approving which amendments they want to send out to the owners for the owners to ultimately vote on. So I don't really have much of a legal issue with the 48-hour notice. Regarding the process, you mentioned the word ratify, which is just a fancy word. That's a concept in corporate law, which essentially means approving something after the fact. So you're 100% right. Board members should not be voting on substantive issues via email, and there's statutory language that prohibits that. It's not unheard of that sometimes housekeeping or administrative choices need to be made, and it wouldn't be improper for the board to ratify it at the duly noticed board meeting with the minutes reflecting that. Based on what you're sharing with me, if the amendments are sent out to the owners, they get the required approval for what your specific governing documents require, and those amendments are then recorded in the public records. My humble opinion is that the process ultimately would be viewed okay. It might not have been the cleanest or the most preferred way as far as them initially saying via email which ones they wanted, but at the end of the day, I don't see any really significant, legal concern that a court or a judge would overrule those amendments that were approved by the homeowners.
Okay. Well, Andrew, I accept and appreciate your opinion very much. May I just ask one last follow-up?
I got to tell you, we've got a board. Excuse me. We just have a board full of calls.
Condo law that the agenda items.
Yeah. So thank you so much. I think we're probably gonna have to move on, but I appreciate it. And just one quick thing. Obviously, this was said at the start of the show, but I want to make sure everyone knows this is good general information. A lot of these are very fact specific, so you of course want to make sure you're consulting with your individual condo, co-op, or HOA attorney on any particular specific fact matter. But thank you so much. I really appreciate it.
Thanks, Douglas. Let's go to Dominic in West Palm Beach. Good evening, Dominic. Are you there, Dominic? Okay, let's go to Lauren in Sarasota. We have a line open right now at 888-565-1470 if you have a question for Andrew.
Hi, can you hear me right now?
We hear you great, Lauren. Go ahead.
Okay, so we're having an election, and I think this is definitely a fraudulent election because it's being held by our property manager who has put us in owner's equity debt of $100,000, and I believe he has a personal financial conflict in this because conflict of interest. Because his renewal of his contract is solely reliant upon one person, the president, and she does not discuss anything with the board of directors as they're too old and they think they're going to a tea party. And so, and I think that the HOA attorney is actually his friend. So there's a conflict of interest there. So I can't contact them. And, I'm retired secretary, so I have no money. I can't pay for anything. But this is so obvious that the only way he gets renewed of his contract is by the president. And so therefore, he's in charge of collecting all the ballots that come in, and he's in charge of counting them. And obviously, it would behoove him to make sure that the people who get on the board will be in his favor of renewing his contract, which was in 2011, 13 years ago. And the president just keeps rolling it forward, and the rest of the board don't know anything from anything. And I bet that the president's getting a kickback in order to just carry on this 13-year-old
Gotcha.
contract with this dude who has put us $100,000 in debt. I believe this is
Okay.
a conflict of interest.
Okay, so another multi-layered question.
Andrew, I didn't know if she was talking about the Broward Election Board or if she was
Yeah,
talking about
I know.
her association. Go right ahead.
I know it. Florida is famous, or infamous, I should say, with election stuff. The first thing, and this is just a general piece of advice, there may be some funny business going on, but I generally advise people, you don't want to allege, that someone's taking a kickback or taking money without really solid evidence of that.
Right.
So that would just be my first point. My second point is all of the voting materials, the ballots, the proxies, the sign-in sheets, that's all part of the official records of the association, whether it's a HOA, condo, or co-op, that must be maintained for at least 1 year. So if there's any issue with, perhaps they weren't tallied right, certainly owners have the ability to have access by submitting a written request to have access to copy those official records. And if you think there's, an election problem and election challenge, make sure one's filed within 2 months of when that election was held. Regarding the president sort of rubber stamping everything, ultimately, just because someone's a president, it's a majority of the board who has the authority to hire vendors or renew vendors. No sole board member on his or her own has that unilateral authority. And finally, it sounds like you do have a lot of, perhaps bona fide concerns with the way things are run. From a practical perspective, my experience is sometimes the best route, certainly if you don't have the funds to perhaps hire your own attorney, is to inform the other owners of what the factual history is, to explain to them why, in your mind, the best course of action perhaps is not to re-elect the same board. And oftentimes that is a way to get to where you want to go. If all of that does not work and the same board's elected and you're able to get a majority of all of the owners to agree, there is a recall process that the owners have. You can recall and remove members of the board from serving with or without cause. So you don't even need to prove that they did anything wrong. You just need to get majority support. So I wish you the best of luck, and hopefully things smooth out for you.
Thank you, Lauren.
Okay,
hey, we got to
thank
go
you.
to
I
break
appreciate
right now. We got to go to break.
Where would I file that complaint? You said file it within 2 months.
Sure. The state of Florida, the Division of Florida Condominiums, they have jurisdiction over both homeowner association elections and condominium elections. So I wish you luck.
Thank you kindly.
Thank you, Lauren.
Thank you
hey,
very much.
We're going to go to break right now. We come back, we'll have Barry from Miami. This is the Ask the Expert Show. We're with you every Thursday night. We're sitting here with board certified Andrew Black of K. Bender Rimbaum. We'll be right back.
K. Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida, with offices in Pompano Beach, Palm Beach Gardens, Tampa, as well as in Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law, and they assist clients with all matters of community association legal issues while keeping them up to date on new developments affecting their associations. K. Bender Rembaum is also a well-known provider of free legal education, which often includes CE credit for managers and state certifications for board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or just write to them via email at info@kbrlegal.com.
And we're back. This is the Ask the Expert Show with you every Thursday from 6 to 7 p.m. We've been doing this now for 8 years now on 1470 AM, 96.9 FM, 95.3 FM, and iHeart Radio. The firm that we are our expert tonight, and we can call him an expert because he's board certified. We have Andrew Black here from K. Bender Rembaum. So we have lines open now. So if you have a question for Andrew, now is the time to come in. Phone number here is 888-565-1470. We're in a new studio tonight. God, I actually feel like I'm like talking different than I normally talk. I mean, this is a very cool studio. Thanks to amp2.tv. I'm going to tell you something, Andrew. You're going to love this next caller. I believe he's an attorney. Maybe retired attorney, but he's always has the greatest questions. Good evening, Barry from Miami.
Hi, Steve-O. Hi, Andrew. How are you?
How'd you like that? How'd you like that intro, Barry?
I loved it, but all I have to say is that Andrew gives awesome webinars, and Steve-O, you have a terrific program.
Checks in the mail, Barry.
Thank you, Barry. Very, very kind of you.
Yeah, 2 one-sentence questions. The first is, how is a coastline defined?
Okay, I'm not sure I have a one-line answer for that. I know this was a topic. You're talking about the new Senate Bill 4D, obviously, and likely regarding the milestone inspections. And if you're within 3 miles of a coastline, you've got that 25-year time frame. I know this was a topic to get all those terms defined. I don't have the exact term off the tip of my tongue. Hopefully, that's one of the issues that will get flushed out.
Okay, and my second question: if somebody has an underground parking garage and it is a concrete floor, and from the floor to the ceiling is 11 feet, is that a story?
Right. So you asked another great question regarding a defined term regarding the new Senate Bill 4D. And as far as, the buildings that it applies to are 3 stories or higher. So obviously that begs the question, the definition of the story. And there's language, I believe, in the Florida Building Code that addresses it. But I do share, if this is where you're going with it, I do share that the new bill could clarify a bit the precise definition to avoid any vagueness or uncertainty regarding that type of fact pattern that you just spoke about. And not to plug our firm, but Jeff Rembaum, the partner that heads our Palm Beach Gardens office, I believe he's just wrapping up a article that will hopefully be put out definitely on our website. I believe it'll be in the Florida Community Association Journal that addresses some of these areas in the new Senate Bill 4D that hopefully will be cured in the next legislative session. So Barry, you're drilling down on some great stuff, and hopefully we'll get all this clarified so we all can get clear on these things.
Okay, thanks, and keep
Thanks,
up the
Barry.
good work.
Thanks, Barry.
Okay, I got to do this to you. In a way, I kind of hate to do it, but I get the emails, Andrew, and I got to tell you, I don't even know if condo owners, people, HOA members bring this up, but I got to tell you, there's a lot of residents out there who are, we're in our demographics here. We have an older demographics here. And I got to tell you, people are scared. They're scared because homeowners insurance is going up. The more companies that go out of business, the higher their insurance goes up. They're afraid about their property values going down. They're worried, really worried about these new laws that are going into effect and the reserves, the way they're going to be handled, and how are they going to afford to live there anymore. Do you have any words that might make someone a little bit happier? Because they're really worried, Andrew. They really are.
Yeah, and it is. It's a very serious matter. I would say the new safety bill, that Senate Bill 4D, is probably one of the most significant pieces of legislation that's impacted Florida. I know we've spoken about it, other colleagues on your show. Our firm's given dozens of presentations on it. And the bottom line is there is some cause for owners to be aware. Whether they should be worried or not, I'm not sure. But I do think it is certainly likely that the cost of being an owner in a co-op or a condominium, certainly 3 stories or higher, it will invariably increase. It just will. That horrible tragedy that happened when the condo collapsed, we all knew that there was going to be some changes to the laws to try to hopefully not have a fact pattern where an older, aging high-rise where they had an association kick the can down the road, right? And not spend the money, not reserve enough to get these required structural repairs done. So yes, they're as the law stands right now, condos and co-ops, January 1, 2025 will not be able to waive the funding of those reserve funds. Reserves are just those rainy day money that condos and co-ops set aside. God forbid there's an act of God and something happens, the building has money, or they don't have to special assess. There's that pot of money available to them. So, I do think all boards, if they haven't already, should start planning now to do a absolute careful look at what their financial health is, to start meeting with the engineers, start meeting with your attorney, getting your ducks lined up, so you're prepared for the likely increase in regular assessments, and there could be certainly some communities may have special assessments as well.
Are there enough engineers in the state of Florida to handle all this work that's going to have to be done?
It's a great question. The consensus is somewhat split. You speak to a handful of people, they think there will be. I think the knee jerk, and certainly my intuition is, it seems like, wow, that's going to be tough for all of the engineers to handle all of the visual inspections. If there's more destructive testing that needs to be done, it certainly seems like that may be one of what we call the unintended consequences of this new bill, right? Where all of the intent was great. We want to ensure that associations, that the residents are protected, that repairs are being done, that reserve monies are set aside. But there are, unfortunately, there's always unintended consequences. One of them is practically, will there be enough qualified professionals, qualified engineers to do this? The fact of the matter is, it remains to be seen. We have to hope that there will be. If not, certainly the lobbyists and the people in Tallahassee are going to have to be made aware of that. So there could be maybe some adjustments going forward.
Okay, if you've got I get people email me and say, we always try to call into your show, but the lines are always busy. Well, guess what? Now's the time to do that now. You can call us right now at 888-565-1470 if you got a question for Andrew. We're going to start going to questions that you have written into us, and we'll get Andrew's opinion. So, but if you'd like to call, 888-565-1470. Your firm does, I believe it's called Ask the Lawyer, and I've been to several of them, and it's funny because there's usually about 50 or 60 people there, and they bring their question in, but then they hear others ask their questions. All of a sudden, they got 10 more questions. So
Absolutely.
you might have a question now, and I would love for you to call and ask Andrew. 888-565-1470. Hey, let's go to our friends, our listeners who have taken the time to write in, and let's start with Jazz in Fort Lauderdale. He says, our association has 3 phases, each independent of each other. We have only one website. Owners can only access their, I guess it's respective phase. Is this acceptable?
Right. So it sounds like he's asking about, there's language in 718 of the Florida statutes, that's the Condominium Act, which provides that if you have 150 or more units, if your association manages a condominium with 150 or more units, you need a website, and it's a password protected site where owners can log in with their own ID and password, and the association is required to post various association records on that website. It sounds like this might be a multi-condominium without getting too complicated. That means where there's one corporation, one association, one board, and that association manages multi-condos. If that's the fact pattern for Jazz, then all of the condos should have access to that association site. Alternatively, if it's 3 separate corporations, 3 separate boards, then if you're an owner in Corporation 1, you shouldn't have access to the website or the records of Corporation 2. But if it's just one association, one corporation, in my view, you should have access to all of the association records on that website.
Again, our phone number here is 888-565-1470. I thought this was cute because a lot of the condo associations, the women have card games, might be mahjong or whatever they play, and there's several. One of them is a very big complex. I'm not going to say the name of it, but they have 60 women who play cards every Tuesday, and they listen to your show. They
That's
have
great.
it piped in into the card room. So her name is Connie. She's in Deerfield. She says, love your show. I haven't missed a show with the girls this year, and I'm so glad you've added a second show. Well, so are we. We received on, let's see, it's our 2022 estimated expenses and 2023 budget this week. It does not show all the checks that were written, paid in 2022 of this year, thereby showing we're under budget instead of over budget. What are your thoughts?
Right. So it sounds like that fact pattern calls for a request to review what the financials actually are. Because if there's some confusion or there's some checks that should be posted that were not, you got to get to the bottom of it, because it shouldn't be an unanswered question whether you were under budget or you were over. The board, certainly management, if you have management, and the owner certainly should be aware of that. So that sounds like something that certainly needs to be reviewed further to make sure your financials are accurate. And certainly, as you all know, every association has to prepare a financial report each year, which owners also have access to.
Phone number here is 888-565-1470. We're here with Andrew Black, K. Bender Rimbaum. Not only do they have offices here in Pompano and in Palm Beach, but they're also in Tampa and soon to be Orlando.
Yep.
Remember
Yeah,
us small people, Andrew. Remember us small guys.
We're super excited about that. We love meeting people from all across the state of Florida, whether you're in a 5-unit condo or a 500-unit condo. A lot of the same issues arise, right? You're living with shared walls, you're living with boards, rule enforcement, you got contracts happening, you're collecting assessments, and it's we certainly love the opportunity to serve more and more of the state. And yes, we're very excited. The Orlando office should be physically open very, very soon.
Wonderful. Hey, this is a letter we got from Bobby in Delray Beach. He wants to know, it says, can our board use any surplus in the operating fund for projects without the homeowner's approval?
Right. So interesting question. The first thing that you need to do is look at what your governing documents say regarding surplus funds. There might actually be language in there. Surplus is just a fancy word. You have extra funds, right? The board has an obligation each year to make a good faith estimate on what the anticipated expenditures will be. It's an estimate, right? It doesn't always come out dollar to dollar. So if you do have extra funds at the end of the year, you're going to want to check to see what your governing documents say regarding those surplus funds. If your documents are silent, which I have to say is likely the more common occurrence, in our view, the board can utilize its reasonable business judgment to use those surplus funds for a bona fide association expenditure in the upcoming year. I will also point out one thing. Dealing with surplus funds, whether you choose to roll over those funds, you're going to want to get with your association financial professional, because there could be some tax filing implications with that rollover of surplus funds.
One more before we take our last break. Mary Ann in Boynton Beach. Can our board tell us the meeting is just a workshop, which I've heard that used before, but not a meeting, and does that give them the right not to notice the meeting? Don't the unit owners have the right to attend these meetings, and is there really a such thing as workshop?
I love this question because I think it really gets to the heart of a lot of issues in communities, which is what? Transparency, right? Oftentimes, a common complaint you get from owners is that they don't know what's happening. The board conducts the business of the association behind closed doors, and that's not the intent and the spirit of what the statute requires. What the statute says is meetings are supposed to be noticed and open to the owners. There's a couple exceptions if you're meeting with your attorney to discuss litigation matters, or if you're discussing personnel matters. But besides those exceptions, meetings should be open to owners. Now, that's when a quorum of the board, so quorum is a fancy word, just means a majority of the board. If there's a majority of the board and they're making decisions for the association, they're conducting the business of the association, that should be a meeting that's open to the owners. And I usually tell my boards, they know deep down if they're meeting behind closed doors. They know if they're essentially just rubber stamping things at the open board meetings that were really decided before they got there. And that's not what the law wants. That's not what the law is intended for. So my guidance to boards are, you want to be cautious about holding these gatherings under the workshop guise. Having said that, the case law in Florida is not crystal clear on this. So it's not like there's one case we can point to where a judge has ruled the physical presence of a quorum of the board is illegal. And I'll give you a quick fact pattern. Let's say your board is five. You have 5 members of the board. Quorum would be 3. You have 2 hanging out by the pool. If a third member of the board just pulls up a chair for a minute and just comments, I think we need to pressure wash this deck. Well, you have a quorum of the board. Is that a meeting that the third board member has to run away from? Probably not. That's probably an overly aggressive interpretation. So, it's better to be conservative, but, you don't want absurd results either. So.
Okay, let's, we're here with board certified Andrew Black. Andrew, can you give us the number at the office?
Absolutely. Our number is 954-928-0680. We have a toll-free number as well. It's 800-974-0680. Again, we have offices in Pompano Beach, Broward County, office in Palm Beach Gardens. We have a Tampa office. We have an Orlando office that's opening up very soon. By appointment, we have a Miami office as well. So we are available, certainly, no matter what size your community association, condos, co-ops, HOAs, office condos. We certainly are well versed in all of those types of real property ownership, and look forward to hopefully working with some of you out there.
Okay, let's go to break. We come back, we'll have more with Andrew Black at the K. Bender Rimbaum Law Firm. We'll be right back.
K. Bender Rimbaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida, with offices in Pompano Beach, Palm Beach Gardens, Tampa, as well as in Miami-Dade by appointment. Several K. Bender Rimbaum attorneys are board-certified specialists in condominium and plan development law, and they assist clients with all matters of community association legal issues while keeping them up to date on new developments affecting their associations. K. Bender Rimbaum is also a well-known provider of free legal education, which often includes CE credit for managers and state certifications for board members. Contact K. Bender Rimbaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or just write to them via email at info@kbrlegal.com.
And we are back. This is the Ask the Expert show. We're with you every Thursday night from 6 to 7, drive time. If you're in your car, you definitely don't want to miss one of our shows. Tonight we have the K. Bender Rimbaum Community Association law firm. I can say this. They're one of the largest law firms when it comes to condo and HOA law. Let's go to the phones. Let's go to Lynn in Hillsborough Beach. Hey, Lynn.
Yes.
How are you doing tonight?
I'm doing great, thank you.
Good, bud. Got a question for Andrew?
I do. Recently, maybe I should turn off my radio.
Please.
Okay. Recently, our association amended the bylaws to include requirement that the owners had to replace their windows and sliding glass doors because our insurance rates were going to double. And I'm wondering, am I required as an owner from 1995 when I purchased to replace my windows and doors before they changed the bylaws? That's my question.
Okay, so just to clarify, so that amendment to compel owners to install that hurricane protection, that's already been approved by the owners and recorded with the Broward County? Because you said you're in Hillsborough.
Yes, according to the
So is that-
association, it was just recorded.
Okay, and that amendment requires owners to install code compliant hurricane protection?
Yes, it requires the owners to install hurricane windows and sliding glass doors that meet
Okay.
the up-to-date
Current
code.
code. Sure. So yeah, so that's not an uncommon amendment. We've actually assisted some of our clients with implementing that. If the amendment was properly approved by the owners, there's a presumption under Florida case law that it's valid and enforceable. So if the amendment requires current code compliant hurricane protection and you do not have it, in my view, that is something the association could enforce. Even though you've been an owner for a long time, there's a Florida Supreme Court case that holds that the governing documents had an amendment provision in them when you bought, which essentially put owners on notice that the governing documents could be amended in the future. So if this hurricane protection amendment was properly done, it's certainly something that the association could enforce.
Okay, now if a person has difficulty of a financial hardship, is there something that can be done with respect to that? Not replacing the windows, or are they going to come in?
Yeah, I mean, that's certainly something that particular owner would need to raise with their particular board to see what type of perhaps financial accommodations could be done. Oftentimes, amendments of that type will have built into it something that we call self-help, which if the owner doesn't timely do it, it specifically authorizes the association to perform the installation for the owner, still at the owner's expense. But perhaps your board would be willing to defer the payment maybe over certain months or something like that. Obviously, that's something you would need to individually raise with them.
I see. Well, I thank you very much for your expertise.
Thank you.
Mine are Andrews.
Right. Yeah. Yours, Steve.
Yeah, right. Okay, listen, we've got a few minutes left for if someone would like to call in, 888-565-1470. I've got a letter here from Ken in Coconut Creek. Our board is considering changing the canopy to a different color. Is that considered a material change? Should we get a vote on that?
Sure. So I'm going to take the assumption that Ken lives in a condominium association, and he's talking about the concept of material alterations, which I'm sure some of the listeners have heard before. A material alteration has been defined as a perceptible change in basically the way the common elements look. And there is arbitration decisions and case law in Florida that has held that even a change of color, we may think it's minor, but that a change of color does qualify and does constitute as a material alteration. Now, the key part is whether an owner vote is required for that change of exterior color. It's a two-step analysis very quickly. The first step is check what your documents say. Oftentimes, the condo governing documents will have a material alteration provision, and you follow what that says, and may require owner vote, 2/3, 75%, majority. It may even allow the board on its own to perform that alteration, provided that the alteration doesn't exceed a certain dollar sum. So you follow what your governing documents say. If your documents are silent, then you have to default to Chapter 718 of the Florida statutes, which does require 75% of the owners to approve that material alteration.
Okay. You know, Kay Bender Rimbaum has been with us, gosh, going on 6 years now. In fact, they will be back with us. One of the senior partners will be with us next week. And get your questions in. You can send them to Stephen at AskTheExpertsRadioShow.com. That's Stephen at AskTheExpertsRadioShow.com. And maybe we'll get one of your questions in. Here's one from Peter in Boca Raton. To record a meeting, can you just notify that you will be recording meetings for the whole year?
That's an interesting question. So we get asked variations of the ability of owners to record a meeting, whether it's a meeting of the board, a meeting of the owners. And the answer is yes. Owners do have the statutory right to record a meeting of the board. What the law says, though, it allows the board to adopt reasonable rules regarding that recording process. And those rules can include, if so desired by the board, a requirement that the owner notify the board in advance of his or her desire to record. So if there's a rule that says you have to tell us before every meeting that you want to record, in my opinion, that would be an enforceable rule. And to avoid any issues, the owner should certainly just follow that rule and tell the board in advance. Also, you have to make sure certainly that you don't use any, distracting equipment. I always tell a funny story. I went to a meeting one time and an owner showed up with almost an entire Hollywood crew. There was a guy holding that big mic and lights and all of this stuff. And certainly the board's not required to allow that type of extensive recording equipment, but certainly they can't prohibit an owner from wanting to record.
Here's a actual board member, Kim and Davy, says, I'm a board member and I love your show. Another one of your cousins, Andrew. All my board members, and we are new, listen to your show and we learn so much. We have a townhouse. We're a condo. Are we, I guess writing is kind of difficult. Are we responsible for the new roof repairs? Our roof is 30 years old. Is a 30-year-old roof, is it, I guess, insurable?
Insurable, right. So, yeah, look, first of all, that's definitely a question you want to get your insurance agent involved with. There's terminology regarding what the remaining useful life is of that roof. Oftentimes you hear 30 years. Whether the carrier will, whether you can get a policy on it, I mean, that's up to the underwriter, obviously. I would suspect that it probably is insurable. But if it's that old and you're on your board, you need to make sure that all the maintenance and repairs are timely done if it's the association's obligation. I will share with you, attached townhomes don't always have the same maintenance allocation between the association and the homeowners. So you need to check your governing documents on who repairs what. Some attached townhomes, they say the association repairs all of the exterior, but not all of them do. So you want to make sure you're fully aware of that.
Well, I got to tell you, the show always goes by so fast. And Andrew, we hope that you will be back again with us. It's been a fun hour. The name of the firm is Kay Bender Rimbaum. Can you give everybody the phone number again?
Sure. It's 954-928-0680. Our toll-free line is 800-974-0680. look forward to hearing from some of you. And go Ravens. I'm watching my Ravens play the Tampa Bay Bucks in about an hour or so. So that's the Ravens sign behind my head there. So
Andrew, thank you so much.
thank you.
This is the Ask the Expert show. In 2 weeks, and by the way, Kay Bender Rimbaum will be with us again next week, but in 2 weeks, the Eaton Critique show, we are going to start going into restaurants that have been shut down by the health department and find out if they have fixed the problem, and we're going to do it on video. It's going to be a lot of fun, and we've got a great restaurant coming on. That's in 2 weeks. Thanks for listening to us tonight. This is the Ask the Expert show with you every Thursday night from 6 to 7. We'll see you again next week.